right is Mark Gottlieb, who is at the Public Health Advocacy Interest Center, and Steve Gardner, who's at the Center for Science and Public Interest. Mark, why don't you tell me what the Public Health Advocacy Center does?
Sure, yeah. The Public Health Advocacy Institute, we're actually here at Northeastern University School of Law and have been around since about 1984, and we do research on public health law and policy, as well as providing technical assistance to those who are trying to implement public health interventions in the states and communities. We've focused primarily, originally our focus was exclusively on tobacco and tobacco control and tobacco litigation as a public health strategy. And for the last, 6, 7, 8 years now, we've broadened our focus to include obesity prevention and other public health legal issues as well. And president of our institute is law professor Richard Daynard, who couldn't be here today.
Mark, thanks. Steve?
The Center for Science and the Public Interest, which is happily abbreviated as CSPI, was started about 40 years ago by 3 scientists, one of whom, Mike Jacobson, remains and is our executive director. The parts of CSPI I've had nothing to do with have done wonderful work over the past 40 years. I'd worked with CSPI since the early 80s when I was with the New York Attorney General's office. And how many people here know CSPI? Because you shouldn't be here if you don't, basically. I'm not talking about us. It's a great group. It is one of the best advocates for health and nutrition going in the country. It is again, except for the Litigation Project, a highly credible and well-respected bunch of people. About 7 years ago, my boss, Mike Jacobson, decided that he wanted to find a way to encourage private litigation in anything involving food and nutrition, including health, food safety, but as we're going to talk about now, obesity issues. And he recognized that there weren't any private lawyers bringing these kind of suits and decided to create a project, the Litigation Project. It's a cleverly named one. And because none of the lawyers who did work at CSPI, when asked, could point to a courthouse, they hired me. My background is in plaintiff class action work as a private lawyer and predominantly in a variety of public jobs as a consumer advocate. So that's what we've been doing. It has actually worked very well to get a lot of change, to drive the underlying agenda, help out the underlying agenda of CSPI. So happy to be here.
I'm at the National Consumer Law Center, and we're also about a 40-year-old organization that represents low-income and elderly consumers in the area of consumer finance. And one of the things that's very interesting in terms, we don't do anything to do with issues of food and product safety other than financial product safety. As we were discussing beforehand, what I do has nothing to do with what you guys do, but has everything to do with what you guys do as well, particularly in the area of litigation, in the sense of using litigation as a tool for social change, whether it be a catalyst or as a way of identifying issues. Litigation very often is where the dialogue or the discussion starts. And so we're going to be looking at litigation both in isolation but also in the context of a broader plan of social change and what role it plays and what challenges it faces as you try to use something as awkward as litigation in order to accomplish change and how that operates. I should also add, by the way, that this is in fact a dialogue, but it's not merely a dialogue with just the three of us. We hope to include you in the dialogue as well. And in order to make this actually work well for everyone, we do have a microphone right here. So if at any point during the conversation you don't have to feel like you're being rude or you're interrupting, we'd love to have you come here, and if we see someone standing at that microphone, we will know that you are there to ask us a question or to engage in the discussion with us, and we'd love to have you and encourage you to participate as well. So to start out, what we'd like to be able to do right now is to bring you a word from our sponsor. But in this case, it's not really our sponsor. It's maybe our catalyst more than our sponsor, as the case may be.
I like to think of it as my defendant.
Your defendant. There you go. So as they say on the tube, let's go to the tape.
Dad! Can I parachute out of my bedroom window?
No.
Can I grow a mustache?
No.
Can we go shark fishing?
No.
How about we...
No.
Dad, can I have a pet monkey?
No.
Oh, darn. Beekeeping!
No.
Dad,
What?
can we go to McDonald's?
Yes. Yes, we can.
Can I drive?
No.
Oh.
What you want is what you get. Mark, what the heck does that have to do with obesity and obesity litigation?
I don't know. I'm loving it myself. But, looking at that, almost any of the things that the child is proposing to his father is probably safer than regularly eating at McDonald's. It's kind of, that's an old commercial. It's nostalgic. It's somewhat quaint, and I think it's actually pretty clever and very different in I think in many ways than what we're seeing today in the terms of the types of marketing directed particularly at kids for fast food and junk food, where it's more pervasive now. There are more venues for marketing, and we don't even realize sometimes that it is marketing that we're exposed to or that the children are exposed to beyond TV. There's web, print, there's games, there's tie-ins. There's almost any junk food is now deeply intertwined with entertainment franchises. So there's this connection going on between, whatever it is, SpongeBob or Dora the Explorer or whomever, and all the other foods that are associated with these entertainment franchises. Their marketing today around this stuff is probably much more cynical than it was back in the day that ad was produced. In that, with the Happy Meal toys and other giveaways and contests and tie-ins to video games and free games on the web that tie into fast food and junk food are all over the place. So. I think that was almost refreshing to see that McDonald's ad compared to the marketing environment of today. So today, really around 2001, 2002, we started to begin to appreciate sort of the gravity of the obesity epidemic and the dramatic increase over the previous decade in childhood obesity. And so I think it became naturally people looked at what was the big public health concern around chronic disease and products, and that was cigarettes and tobacco. And in the 1990s, there was this tremendous wave of lawsuits involving the tobacco industry, and they resulted in some enormous jury verdicts of, one jury in Florida issued a $150 billion punitive damages award in a class action. In an individual case in Los Angeles, there was a $28 billion punitive damages award against Philip Morris. There was all the state attorneys general were involved with litigation against the tobacco industry, and in 1998 they settled with the industry settled with the states and are paying somewhere more than $200 billion to the states sort of in perpetuity as a result of that settlement. And so the food companies were watching this and became a little bit concerned and that they would be next. And a lot of people thought that they might be next. And sort of hence the cheeseburger bills were born in the early 2000s. And this legislative initiative really started with the food companies, with the beverage companies, and with their front groups, most notably the Center for Consumer Freedom, which was a Rick Berman organization, and he had played a role in helping out tobacco companies and with alcohol beverages, and he does a ton of stuff. But he did the Center for Consumer Freedom as well, and they launched TV spots that portrayed this wave of obesity litigation that was expected to be happening as being backed by very greedy trial lawyers who were trying to take away your right to enjoy foods and beverages. And whatever happened to personal responsibility, and we saw that in editorials, op-eds, and commentaries that were all over the place in 2003, 2004, 2005. The personal responsibility in Food Consumption Act was passed by the House in 2005, and this would have immunized the food industry from any sort of liability around obesity. There was a Senate version of the bill that failed. It also failed in the subsequent version of Congress. But what did happen was that 24 states adopted these cheeseburger bills, or common sense consumption acts. And so in about half the country now, you cannot hold food companies liable for the effects of their products in terms of obesity. Even deceptive conduct by food marketers may be prohibited in terms of legal actions. These are kind of loosely based on sort of the restatement second of torts 402A comment I, which exempted tobacco and butter and other products from liability, and that was adopted in many state consumer products liability acts. And so now this was pretty successful, and you kind of wonder what all the fuss was, and maybe Steve, you can tell us about this big wave of litigation that had paralyzed the food industry with fear and gotten them involved in this major lobbying effort that was fairly successful.
As a taxpayer, I was particularly irritated by Congress spending a lot of time trying to enact a bill that was designed to address the myriad of lawsuits that had been filed for cheeseburgers making me fat, that is still the only lawsuit saying cheeseburgers made me fat. And the Senate version that we worked on when it was in its dying stages to prevent, together with Public Citizen and some other folks, it was far broader than what it purported to be. It purported to be, you can't sue saying a cheeseburger made you fat. It really preempted almost all state consumer protection laws, not just on obesity claims, but any claims involving foods, as Mark has alluded to. I don't know the details of the state laws because CSPI brings lawsuits in states where it would not be futile to sue. And there is not, if you had two Venn diagram sort of things, if you had a circle with all the states that had enacted these laws and then all the states that don't totally bite it when it comes to consumer protection law by bad law or more frequently hostile courts, they would never intersect. So we only play with the states that play fair by their consumers. I don't know the effect of them, but if they have the similar preemption language, it's really bad, and it is indeed highly cynical. People were told a bill of goods. The congressmen knew what they were doing.
Steve, one of the things, there have been, for years, there have been product liability cases, there have been misrepresentation and false advertising cases. We're talking specifically about obesity. What is an obesity case, and how does that differ from the kind of more traditional tort kind of case that we've seen for years?
The Pellman versus McDonald's case is that myriad of lawsuit I referred to. It said, on behalf of two teenagers in New York, that they were pulled into McDonald's by McDonald's advertising, including a bunch of ads that McDonald's ran in the mid-'80s saying that McDonald's food was nutritious. That was something that was so absurd that the states of New York, Texas, and California attorneys general threatened to sue McDonald's just for claiming that it was nutritious. Interestingly, McDonald's said it was nutritious because it was capable of rendering nutrition, meaning the fact that you didn't keel over dead immediately upon eating it, and your body could process the stuff. It was slightly better for you than cardboard, made it nutritious, but they did stop them. That lawsuit was changed from a personal injury suit into more of a traditional consumer protection suit, saying that not depending on the McDonald's made me fat, because an excellent federal judge in New York, who was a very fair, very honest, and very smart judge, threw that out because he said you're never going to establish that. It became a model, what we in the biz call UDAP law, for unfair and deceptive acts and practices laws, that virtually every state has for a variety of marketing abuses, applies just as well to food as to the kind of things NCLC does. And I may have told you, when I announced that I was moving from private, at the time, practice over to CSPI, Will Ogburn, who is his boss, called and said in his most Will-like voice, he said, "Steve, I'm so sorry that we are losing you in the consumer law field." And I said, "Well, geez, Will, I thought that, stuff you consumed was a consumer good." But it was, and Will's a fairly smart guy, but it does illustrate that the litigation involving food is new. It is using, absolutely, those tobacco lawyers just stole it from us. They use, most of the successes of the tobacco cases were based on UDAP laws. And there, I think, frankly, the parallel ends, because I do think that there is a big food, but it is way more multifarious than big tobacco. It's a lot more difficult to approach. And I got other thoughts, but I'm going to stop singing and ask another smart question.
Well, and actually, I was just going to, once again, to put in another, this one really brought by the sponsors. There is a resource available if you're interested in, and Steve is talking about the application of the UDAP laws, the consumer protection statutes, to this particular area. NCLC provides a 50-state survey of the requirements of the state laws as they apply generically, and I've been told, Mark, that you guys have used that and have now expanded that and using that and specifically applying in the area of food law. So you might want to just talk about what may be available there.
Yeah, absolutely. We will be publishing on our website at phaionline.org. Probably in the first week of February, 50 state profiles on the use of state consumer protection law in terms of curbing junk food and beverage marketing directed at kids. And we're comparing each state which has the favorable standards that would make likelihood of success greater in consumer protection actions at the state level. And we're hoping it will be a tool that will encourage more groups and organizations to jump into the fray along with CSPI.
And a plug, not a plug, but just a reference to CSPI. If you want to see how we successfully and once or twice unsuccessfully used UDAP laws, that little sheet of paper in front of you is how you can get to the McDonald's lawsuit that we recently filed. But if you just go to the main page and look for the docket, which is the litigation group's home, you can see the types of cases we brought everywhere from labeling, just pure fraudulent labeling, to predecessors to McDonald's, such as the work we did working with Dick Daynard and some private lawyers to stop marketing of the sugary soft drinks in schools, and our threatened lawsuit that resulted in a landmark settlement against, or with, because they did settle, the Kellogg Company, whereby they stopped marketing their worst food. We can't make them market only healthy food to children, but we can stop them from marketing the absolute junk to children. They agreed to it, and Kellogg, I got to give them props because they did go further than any other company to date has been willing to go. including McDonald's.
What I want to do is spend a few seconds just talking about, the pros and cons. We have these cheeseburger laws that are out there. What were some of the arguments that were being raised, obviously successfully in those states, given this torrent of case that had preceded it? What were some of the arguments or the theories that were being successfully used, and perhaps what are the counter arguments that have been used to oppose them in those states that have not gone that particular route?
I think, these were pretty simple arguments that were made, and part of it was vilifying the plaintiff's bar, as I had mentioned earlier, and just sort of relying on sort of a visceral hatred of trial lawyers as a key to this. And, I think part of it was the reliance on the argument that, look, people are responsible for their own actions, for their own things. We have freedom of choice in this world, and we shouldn't have courts, lawyers, or legislators telling us what we can and can't eat or drink. I think also, one of the big selling points for the cheeseburger bills is by immunizing food companies, the worst junk foods can be deceptively marketed to kids at the lowest possible prices. So, I'm just being facetious, but that's really one of the arguments there. It's like we need to protect these companies from any sort of liability, and that will keep really the worst foods, which are the most aggressively marketed, out there, and it really kind of falls apart, I think. And in terms of the issue of personal responsibility and choice, I mean, this is key. This is key, and everybody knows that personal responsibility, that individual behavior, is sort of the cornerstone of health outcomes. And the question is, how do you change those behaviors? Do you just use a totally laissez-faire approach? Do you say, okay, look, government, public health advocates should have nothing to do with the decisions people make about what they eat and about how food is marketed to them and how food is engineered to appeal to them? Should we just say, look, catch as catch can, eat as eat can, and there's no responsibility for the corporations themselves who are marketing this stuff, or for government or the public health community to do anything? I think the answer is no. We all have shared responsibility, and the arguments around personal responsibility tend to just point at the consumer or the victim and say, look, it's your own fault. And I think these are hard to break through in some ways, because there is an essential truth around personal responsibility and individual behavior. But at the same time, there is this continuum of shared responsibility which is ignored, I think, in these arguments.
We have a couple of people who have joined our conversation.
Excellent.
So why don't we invite them to...
And I always feel the need to tell people that it is a dialogue and not a monologue.
So I'm not completely familiar with the politics or the legalities, the legal issues of obesity, but I work in public health and nutrition, and I'm wondering if you can speak to how the addictive natures of fats and salts and sugar play into what you're talking about, knowing that they can change consumer preferences and palates.
Well, this is a cutting-edge issue, really, and maybe at some point will make sort of the product's liability, as opposed to the consumer protection approach to obesity litigation, more appealing. David Kessler, the former commissioner of the Food and Drug Administration, wrote a book, I think a year ago or a year and a half ago, called The End of Overeating, and he talks about the way that food companies layer fat, sugar, and salt in order to create sort of a hyper-palatability that makes people crave these foods, and really comes very close to what some people would consider making them addictive, or addictive to certain individuals. The use of monosodium glutamates and other glutamates also have been shown to make foods almost irresistible to some people. And, you know, the question of what's the intent of the manufacturers and how they're engineering these foods and how those play into our sort of our biological systems, our physiological propensities to act in certain ways, you know, it really raises a lot of interesting questions about whether or not these can be addressed in litigation at some point. Right now, I think this evidence is starting to emerge, and it's still at a reasonably early stage, I think, to think about using it in the context of products liability cases. But you know, I think this is a very important area, and hopefully one that the regulatory agencies will start to take a look at as well.
He's right. We have not used it in litigation so far because of exactly what Mark said. It is very much developing science, and the types of lawsuits we bring strike most judges as odd anyway. Those judges are incorrect, with all due respect to those courts that have ruled against us. But I don't want to go in with science that is just emerging. I want to go in, as with the McDonald's case, with science that's a gimme. Are children under 6 deceived by advertising? And the answer is, you betcha, because they have no comprehension what advertising is about. It's still hard because we have to fight, well, it's the parent's problem. But it is, at this point, I think, too chancy to get into it. But you're absolutely right. It is a problem. The companies know what they're doing. Not probably to the extent of the tobacco companies, but they're probably, as I told a general counsel of a food chain, when he said, at least we're not selling alcoholics beverages mixed with stimulants. And I said, well, no, you're not. But you're probably killing more people.
We've got some questions that maybe we'll get to a little bit later, but I also want to point out from the litigation point of view, one of the challenges, not only dealing with the efficacy of the science, is the practicality that as you move from a consumer protection to a product's liability, it becomes a more individualized question. And so the likelihood of being able to bring a class action, which is, after all, the more effective, cost-effective way to be able to bring the litigation, becomes more difficult. The reason why the judge in Steve's case threw that out is that it's very difficult to prove in a misrepresentation case a class, because you have to show that the individual members reasonably relied upon the misrepresentation, and that's a very difficult thing to do in a class action setting. We'll talk a little bit more about that. Not always, but
which is those states that I don't litigate in would do that more.
We'll talk a little bit more in terms of litigation, but there is a very practical procedural issue in the litigation that prevents you to move there, because as you do so, you're moving from a class situation where you're focusing on the behavior of the defendant to a situation where you have to bring an individual case where the individual brings certain elements to the proof. We had 2 questions. Did you have still a question?
Well, I think I'll hold off
Okay.
until
We have someone else, and we have another question here?
While he's coming down, Stuart, let me caution folks. I'm sorry, I saw him jump. I'm only talking about class actions in the kind of suits we bring for the exact reason Stuart is saying about the problems of getting mass change through a products case.
I'm Leslie Friedman. I'm with the Public Health Advocacy Institute. I'm not a ringer.
Right.
When you talk about personal responsibility, meta level, when you're talking about public health, personal responsibility, I mean, for instance, if we left it up to everybody to purify their own water, that would probably not be a very effective way of looking after everybody's health. Is the idea of initiating lawsuits to try to provoke a conversation and a movement towards a more global way of addressing this, like through legislation and all of that, or is it a recognition that legislation isn't going to be effective, either be passed or be effective? Or do they coexist because that's
the reason CSPI started the litigation project this is Margot Wu-Tan, who's the head of our Nutrition Policies Project. Dr. Wu-Tan has the joy and privilege of not being a lawyer, but when she was asked, why is CSPI getting into private litigation? She said, well, we went to Congress and nothing worked. We'd been to the FDA and the FTC and USDA, and they didn't do anything. We were out of branches of government. I see our job, I see the job of any litigation as something you step into when everything else fails. I don't see it with respect to CSPI as a way to drive the discussion as the reason for bringing the lawsuit. We bring the lawsuits that we're willing to take to trial because we know we should win, even if we know we may not. I think it's dangerous in some instances to bring a lawsuit that will just foster public discussion, because what you often get, and what I've seen others who've done that in this area achieve, is litigation that bugs the judge, and then the judge, in an effort to get rid of it, makes a ruling on a motion to dismiss that is legally unsound, but is driven from the fact that the judge thinks it's an absolute silly lawsuit. As an example, a group that was a good group, it's a vegan advocacy group, and they're so good I'm not going to mention their name, brought a lawsuit against, I think, the California Dairy Producers Association, saying that those, in my opinion, not that they're not deceptive or whatever, but lovely California Milk Board ads that said California cows are happy cows. Y'all know that? That it was deceptive because the cows were not, in fact, happy. Now, that's true, but that's pushing it. Bringing a lawsuit against a milk product because it doesn't have a lactose warning on it is also true, but pushing it. For that reason, we're not going to do that. We're pushing our luck as it is. The McDonald's case is solid on the science and solid on the law, but we're still going to have a very difficult fight because of all the parental responsibility and other leitmotifs that the evildoers have managed to put to play in this country.
And what the McDonald's suit has done, and we're not talking about the Pellman case now. We're talking about CSPI's current litigation against McDonald's over the use of Happy Meal toys to lure children into McDonald's through nagging. And into a bad nutritional environment, to say the least. I mean, what this has done, and people may disagree with the litigation, and there may be a lot of negative publicity around it. But it has really created this dialogue around whether or not this is an ethical thing to do, whether or not regardless of the legal merits, whether it's ethical to be giving away the toys to lure these kids into what does Mike say, to collect all 101 Dalmatians that they're giving away, this dialogue, I think, is a very positive thing, and this is one of the effects of litigation, and it can change corporate practices either because of a ruling or a jury verdict, or just because of the negative publicity and the way that the public perception of their behaviors has changed as a result of the dialogue, and sometimes you get good things. In the tobacco cases, one of the great things that came about was a cache of internal documents that really explained what those companies were doing and thinking and how they went about what they were accomplishing in terms of addicting 50 million people to nicotine, killing about 500,000 a year in this country. We don't have those kinds of documents with food yet, and those documents, I think, were instrumental in the further regulatory action that came subsequent to those cases, particularly by the FDA. And if we had some more sense of what the food companies were doing and thinking and what their internal strategies were and what their engineering was all about and what was motivating it, perhaps that could also push forward the regulatory agenda to have a real effect on reducing obesity. And that's not going to happen in the absence of some litigation.
We You're right, but we don't need everything because the companies have been pretty blatant about what they're doing. For instance, McDonald's, not to, well, yes, to pick on the worst evildoer of the bunch. McDonald's founder, Ray Kroc, in a crock-full statement, said, and I'm paraphrasing, it's in the complaint, that we knew that if you had $1 to spend on marketing, spend it on the kids because they will pull in the parents. Somebody else working for McDonald's said, you want to get to the parents' wallets through the children's minds. That part of what they're doing is really, really clear. Their marketing intent is to bypass parental responsibility by marketing straight to 2-year-olds. And I don't think we're going to argue personal responsibility for people who are still wetting the bed. McDonald's might, but I don't think anybody else does. And I will tell you, I've seen some preliminary data that the majority of Americans believe that toys should not be used to market junk food, specifically as to McDonald's.
We have another question here?
Hi, my name is Mike. I'm a third-year law student across the river. I've spent
One of your people?
I've spent most of the last 3 years at law school trying to draw attention to the work that's being done at the intersection of law and mind sciences, so social psychology, cognitive science, neuroscience. And I understand that this idea of personal responsibility is really ingrained in the fiber of America. We're sort of this individualistic nation, but from all of the research I've read in the mind sciences fields, personal responsibility, at least to the extent it's sort of probably accepted by mainstream America, is kind of a sham. And you can start by looking at the Stanley Milgram experiments, all sorts of stuff. So my question is, in response to the personal responsibility arguments that industry makes, do you or have you thought about looking at research, just body of research, where you could just manipulate little contextual factors and people's behavior radically to show how these kinds of advertising and other things doing is really changing people's behavior, and maybe the causation is not as attenuated as they. Of course, I understand that opens a huge potential box of where does personal end, but I just think that it seems pretty clear that really influencing people.
Well, I mean, this is why we have a public health approach to things, and why there's sometimes people will characterize that as a nanny state, because in the final analysis we're not all capable of making the right decisions and taking care of ourselves and taking care of our children on every single issue, but at the same time nobody wants to hear that. No one wants to think that actually advertising and marketing affects their decision making. Because we really want to believe that we have total control and free will in all of our decisions that we make around the products we buy, the things we wear, the way we act. I don't know really how this would fits into sort of the legal context, and maybe you do. This is the intersection that you're focusing on in your studies, but certainly the way we see it. Being relied upon by food companies is to take advantage of this notion of individual responsibility that, as you say, is ingrained into the fabric of our culture and society, and say no. It's your choice. You get to choose what foods you eat, and you understand the risks, and therefore, there's the front of package labeling. Just look at the label, and you know what you're getting. And now, of course, there's federal menu labeling laws that was part of our healthcare reform, and an informed consumer is going to make the rational decision. but that really doesn't always happen. And I think acknowledging that it doesn't happen is hard to do, and it's hard to get popular support for an acknowledgement that we don't always make the right choices, and in the absence of some other means of changing behavior through legislative, regulatory, or other legal or policy actions, we're going to continue to have a growing and more serious problem with overweight and obesity in this country that we can't afford. And it's really getting past personal responsibility is going to be one of the great challenges in sort of convincing people to get buy-in for real change.
The direct answer to your question is talk to anybody who works at an ad agency, because advertising exists to make consumers think they want something that they didn't even know they wanted, and make them believe that if they drink whatever that light beer is, the Swedish bikini team is going to go out with me. I tried drinking Diet Pepsi for a long time, and Cindy Crawford never called. And my calls to her just resulted in that, restraining order. But it's all about tricking you into doing something that you don't know you want to do, you probably don't want to do. In the case of, to roll back to McDonald's, it's about getting kids, brainwashing kids into wanting something that they want the toy. They don't want the food. I've heard from a lot of parents who say they have a hard time getting the kids to eat the food. I've heard from a lot of parents who added, thank God. But even, I got asked, I will tell you, we did a wave of press when we announced a notice of intent to sue McDonald's, and then we did another wave when we filed the lawsuit. We had a lot more negative reaction to the first one than the second time, because frankly, we learned a lot from something I no longer have to do, which is to go on to AM drive time call-in shows. But when I did, and when I am asked by a legitimate, by which I mean Fox, so think about what I think of the drive time shows, or a real network, what about parental responsibility? I do something that I hate it when anyone else does it. I don't answer the question immediately, because the lawsuit is about corporate responsibility, about McDonald's responsibility simply to comply with state law, and in the way they market, not to the parents, but to the children. And I also point out something Mark said, even if the parents never take their kids to McDonald's, and we didn't take our kids to McDonald's because of the toy marketing and told the kids that, which I'm sure at 4-year-old they understood the complex, I now know that was as impossible for them to understand as, an advertisement. But if you do prevail, if you put your child in a box so they don't learn about the toys from anyone else, they're going to find out, and what you're doing is you're creating a desired thing when they do become free-range chickens and can go buy their own junk food. And more importantly, from a societal standpoint, even the people who love McDonald's selling everything should be concerned about the long-term impact, which is going to drive up healthcare costs because of type 2 diabetes and the other bad effects of obesity. Again, why blame the parents for McDonald's intentional action when the result is that we've got a sicker and sicker and sicker set of kids that we're bringing up?
You have another question.
Hi, I'm Sheila Richardson. I'm a Breakout here. And I'll give a disclaimer that my question might be of my own ignorance, but I have trouble understanding the effect of your litigation and this idea of consumer choice, because I think just as much as advertising is an issue, economic disparities are. So even if someone has $1 and they know McDonald's is bad for them because they've been convinced by the advertising, they're like, I might get more out of a cheeseburger than 3 bananas, which they can do with that $1. And I know there's constraints, like you can't really, for antitrust reasons, like you can't tell McDonald's they should raise the prices of a burger so that way people can make better choices. But what's the actual effect, even if you get rid of the advertising? Like, how do you
One thing is, I was on a panel, it was at George Mason Law School, so I was swimming upstream on that one. But one guy said, your lawsuit's not going to stop the obesity problem. Why do it? And I said, well, it's a little more than a drop in the bucket, raising people's awareness. And I will admit that although I'm not going to bring a lawsuit to raise awareness, I do know that our lawsuit is helping contribute to people's awareness of the junk food. I went down that path, and I'll be honest, I lost the second point I wanted to make, so I'm going to stop. We'll fix it in post.
I think there are actually two questions that you raised that are very good. The first part of it is what Steve's getting to, and that is the lawsuit itself going to make a difference? And I don't think that anyone who's involved in using litigation as part of not only a social change, but trying to change an industry or particular practice does it in isolation. And that the litigation, although it very often is a catalyst, is always taking place in the context of legislative advocacy, regulatory advocacy, grassroots advocacy, working with the press, and it becomes a part of a more overall. So it's not just the litigation itself. But I think you ask a more fundamental question as well, and that is that maybe the reason why people are exercising their choice is that they have no other choice. And the question is, if the litigation takes away access to this food, what's going to replace it? Is it going to be better, or is it going to be worse? And that goes to fundamental questions in the marketplace. We get that all the time. I get situations, just analogizing, my unhealthy food are predatory loans. And we get the bank saying, you know what, if we don't provide these loans to people, they won't be able to get loans. And my answer is that giving someone who has so little good credit the worst possible loan is not going to make them better. And their response is, but what's their alternative? And the alternative is for us to go back and then work with our colleagues to find better alternatives, to find local banks and credit unions that can provide loans at reasonable levels, and providing other funding sources that can meet those needs across the board. So I think that you're absolutely right. Just litigating to stop the bad practice is not enough. You also have to focus on creating a better alternative for people so they can get nutritious food they can afford, or in my case, that they can get financing that is reasonable and is not predatory for their at. So you certainly stop the bad behavior, but you also have to focus on providing reasonable alternatives that will allow people of all income levels to be able to participate in a safe and healthy way.
And that was, if I could, you reminded me of my second point to you, which is the lawsuit is about stopping McDonald's from putting using the toy to market the junk food. It has nothing to do with the parent's choice to buy whatever version of junk they want to buy the child, or the healthiest version. And I should point out that there's a lot of press I've seen that McDonald's has healthy choices. Well, McDonald's has less deadly choices. The best kids meal you can get is fried chicken and a caramel apple. And that's really not a good meal. It just happens to be less horrible than a cheeseburger and fries. But we're not trying to take that choice away. It's a very sensitive subject because it's a hard one to answer about taking away low-cost food choices. But a lot of folks who work on the impact of food in low-income communities are going to be often all in favor of taking away McDonald's as a low-cost choice and providing other choices. If McDonald's couldn't sell junk, they would sell something healthier, and they would sell it at that same price, because kids' meals are loss leaders designed to get the parents in and spending for the big meals.
Let me just mention that this is going to be a topic for the second Obesity in the Law panel in the afternoon, too. So.
I'm Carol Wolfe from Public Health Advocacy Institute. I think I have something that's responsive to your question in a different way, in that if you look at the annual reports of soft drink companies and food companies, they talk about obesity as a threat to their bottom line, and also concerns about the image to the public of their food products, especially for children. And so one thing that has happened, I feel a little uncomfortable sort of touting this, but the National Restaurant Association has announced that they're committed to increasing the availability of fresh fruits and vegetables in restaurants, which I'm assuming includes large chains, over the next 5 years by a certain percentage. And they have so much clout, it's going to be really interesting to see in the reauthorization of the Farm Bill what role they play in pricing and subsidies for fresh fruits and vegetables. So by lowering the profile or the public sort of exceptions of unhealthy options through some of these legal approaches, there might be broader ripple effects, potentially even in the Farm Bill debate. So that's a response.
We're getting some great questions. We've got another one coming up.
I'm Danielle, I'm with 3L. I'm interested if you could talk about the connection between what you do and disability litigation. I know that the ADA doesn't recognize obesity as a disability right now, except if it's connected to a physiological disorder. And I'm just curious to see if you've thought about that in the sense that America hasn't really, one of our biggest and most important statutes hasn't even accepted that as a serious problem to deal with yet. Can you talk about any connection?
I'm deferring to Mark, and then I will blather too.
Well, you know, the Rudd Center at Yale has really taken the lead in terms of examining bias around obesity, and of course the ADA is a civil rights statute designed to eliminate discrimination based on disability. But as you say, there is this little gap because the effects of overeating and obesity itself does not rise to the level of disability under the ADA. Interestingly, in tobacco, smokers wanted to argue that their addiction to the nicotine in tobacco products constituted a disability and that it should receive accommodations or modifications in policies and procedures around that. And that's actually also not included in the ADA. So I think it's a complicated issue in that clearly there is this bias and discrimination, and at the same time, I'm not quite sure what addressing that would be, what the effect of that would be on reducing or preventing obesity. So, as Steve suggested, I'm blathering on, but it's.
When you shut up, I'll blather. Yeah, keep going. No, go ahead. Did I humiliate you? No, I didn't.
No, I mean, I think it's hard to draw the line around reducing discrimination surrounding obesity to preventing obesity, which is sort of what our focus is. But those don't necessarily have to cancel each other out. I think they need to both exist. And as the obesity continues to be a significant problem, and the numbers of people, the percentages of our population who are obese grows, so to speak. It's important that they are not discriminated against based on the fact that they are heavy.
Mark, before we go to the next question, just follow up on this whole notion of civil rights as well. To what extent has there been any discussion as to whether or not the efforts have been directed at certain ethnic, racial groups as well, and that there may be a disparate impact in terms of how that marketing is being directed? And is there, in fact, a civil rights aspect to these violations? Also income. Obviously, we were discussing beforehand, certain aspects of our society are being focused upon as part of the marketing efforts. And is there a civil rights issue there that goes beyond the issue of obesity?
Yeah, I think there most certainly is. This isn't an area that I have a great deal of expertise in, but in a number of ways, in terms of the sort of the availability, food availability in areas where there's greater levels of poverty. There's almost no produce often available at all. And zoning can play a very significant role. The inavailability of parks for active living, particularly among youth living in at or below poverty, are very significant issues. And particularly around making land use issues, I think there are some very good civil rights-based approaches that can be accomplished. And I know there's been efforts like that going on, particularly out in California, relying on civil rights litigation to create parks and areas for physical activity to occur.
I tried to flag Professor George to come down. That's her with the lovely hibiscus or whatever in her hair. She'll be speaking, I believe, on this topic. I asked her at 2 o'clock, don't be there or be square. We were looking at this and were very discouraged when I know it was the RAND Corporation, or the RAND Institute rather, or whatever they're called, came out with what appeared to be a very fair, they are a non-result-driven organization that said that they could not find any disparate impact on low-income communities as to, I don't know if it's food marketing generally or fast food marketing, and I'm looking forward to learning why the RAND people were full of poop as a Christmas goose, because I was very discouraged by it. And I'd also like to just quickly on the ADA aspect, because I've been a do-gooder gadfly on advocacy for now what I just realized is 35 years, which I need a nap now. I've done ADA cases, both some employment but mostly access cases, so we're aware of it, but there isn't, that guy who had to be hoisted by a crane out of his bed is probably ADA. Even any judge would admit that. However, courts are very unsympathetic right now to ADA litigation, which is odd because ADA was a program and a law pushed by Bush Pare. This was not a radical left idea. It was something that Papa Bush said.
Nelson.
Hi, I'm Nelson. I'm a 2L here. I'm curious about your views on the impact of calorie count legislation. Forcing it to be posted in fast food franchises, and if there's any possibility for litigation from posting false numbers.
Well, I think this is interesting. You want to say that informing the consumer is a very good thing as long as the information is meaningful, and I think that's by and large true. The question I have about the effectiveness of the menu labeling laws is whether or not that really has the effect of then, as we're talking about personal responsibility, putting all of the responsibility on the consumer, as was the case with the cigarette warning labels. Look, it's on every pack. Never mind that it's engineered to be as addictive as possible. It's on every pack. You know how many calories you're getting. It's on the sign in the restaurant. It can cut both ways. As long as it doesn't result in reducing the responsibility of the food companies, of the restaurants themselves, in terms of providing good food, nutritious food that's not engineered to make people just want more. I can't eat just one. I think this is probably a positive development. I'm not sure whether it's going to have a profound effect. I tend to doubt it, and I tend to think that some of these consumer disclosures end up being sounding better than they are in practice. And I don't know how you feel about that, Stu, but I think sometimes you just need a public health approach that says, look, you can't do this.
Yeah, I agree wholeheartedly. I mean, NCLC has always taken the position that disclosures are ineffective. In fact, they tend to be counterproductive because, as you were just saying, they now become a shield. We posted it, it was there, you could have read it, and therefore you acted at your own peril. And disclosures are very rarely read, they're even less rarely understood, and they're almost always used by defendants to shield themselves from liability. And so, to the contrary, I think that's counterproductive. At some point in time, you have to decide that certain behavior just should be stopped and excluded, and merely disclosing it is not going to help. In fact, it's only going to make it worse.
Stuart, you ignorant slut.
Yeah.
The CSPI, with Margot Wutan aforesaid, was one of the primary groups pushing for the menu labeling law. I had nothing to do with it except trying to keep the preemption language as small as possible, but it also, the devil is in the details. The FDA has delayed what it's going to require people to say, but the idea is that when you see cheeseburger, you're going to see 800 calories, double cheeseburger, 1,200 calories, and that's occasionally, I'm a late in life capitalist. That's about consumer choice. That's about consumers seeing it, and it isn't the cynical disclosure, I don't think. The New York experience, because they did require it, was overall positive. You're nodding like you probably know more details about the studies, and I'm going to ask you to do that. But I will say one thing that's very important, that when the FDA finally required disclosure of trans fat on packaged goods in the nutrition facts panel, companies stopped using trans fat. Rather than disclose that it was there, they reformulated. I think that companies, rather than say that the Denny's double cheese burger and fries is 4,500 calories or whatever the astounding amount that it in fact is, they're going to cut back on it because people, I think disclosing sodium is a problem because how many people know how much sodium they should be getting? Yeah. And what do you think it is? Not Carrie, you've already talked. What do you think it is? How much?
Well, it depends if you're nuisance or 1,500 for a higher 22 milligrams.
And we're very hopeful that the new dietary guidelines are going to put it at 1,500 for everyone. But
1,500 for African Americans.
people at risk of heart disease, which is black people, old people like me and Stuart, and not
former friends. Yeah.
Yeah. So I think it will have a good effect. I don't think, again, all of this stuff is like the old joke about 10 lawyers buried up in their necks in sand 10 feet below the ocean. It's a good start. It's not of itself going to fix anything. I am hopeful that we will see the kind of reformative effect that we saw with trans fat.
The problem, and I think maybe that's where we meet on it. My problem is that if you're only going to rely on disclosure and allow the companies to do anything and everything they possibly can in order to dissuade you or to use the three-card Monty so you don't see where it is, that's not effective, and it serves as a shield for them. And I think full, fair, and honest disclosure without the kinds of counter-advertising and schemes in order to delude people would be fine. But just doing the disclosure creates a shield, which they very often hide behind and often disclose.
Maybe in Russia, Chairman Mao, but in this country, we're not going to be able
mixing
to
your
stop.
metaphors there.
I'm quite aware of it.
Or
in this country, we are not going to be able to stop companies from selling the worst food, nor personally do I think they should have to. But I do think that Starbucks should have to tell you the astounding number of calories that are in the double frap venti latte or whatever it is that I had to read about in CSPI's magazine for me to realize it's like 700-800 calories. And I'd rather have a double dip of Haagen-Dazs than a damn funky coffee. And it allowed me to make a choice. This will allow people to make that choice. I think it won't, I don't think it's going to provide so much a defense to an individual lawsuit, because we're not even there yet anyway, where the part of the bill that's just horrific is the scope of the preemption, because it preempts no state can have anything to do with menu labeling anymore except as a warning.
I want to let you speak, but I'd really like you to talk. We have a few minutes specifically to talk about the preemption issue because we haven't talked about it a great deal, but it's something we need to highlight. But why don't you go ahead?
It was just more of a comment in terms of, yes, the New York experience has been very positive. Positive for consumers, positive for restaurants. And just as a personal aside, I know that when my friends and I went out to Cheesecake Factory, that when we saw how much calories there were in the cheesecake, we decided to get one piece and split it among 8 people because it was over 1,000 calories, which for most people that's well over half.
Daily.
Yeah. You know, CSPI had studied casual dining, I think is the category, but places like Macaroni Grill, and some of the stuff that looks healthy is some of the worst that you can get. So there are two people, and I would be one of those people, would be deceived about whether to choose this versus that. And I think that's where the choice is really going to come. It may get rid of some of the worst. It probably will result in them bringing some of the calories down. But the big choice is you can go, I don't need that double cream whipped frap latte venti. I don't order from Starbucks much, so I don't know what they really call them. On preemption.
Okay. While you're coming down, Steve, you just want to, we're talking about litigation, and one of the problems when you do any kind of products liability litigation is dealing with the preemption issue. Do you want to just explain
to call it UDAP litigation?
There you go. So you want to just...
There is I could write the affirmative defenses for the companies because they're all the same. I went to a seminar presented by the Better Business Bureau, National Advertising Division, and one of the defense lawyers there had a list of, I think, 113 affirmative defenses that could be pled that I hope to God I come up against her firm sometimes. I'm looking forward to that. But there is preemption. This preemption exists. We could not affect a lot of details of nutrition disclosure, but in like
there are some people who may not be.
What is preemption?
Explain what preemption, why it's such a significant issue.
Preemption is, let's stick with the federal aspect of it. Preemption says federal law rules, screw states' rights. You do not get to apply your laws, usually under the fictitious concept of national uniformity and how it would be just really hard for these big companies to comply with California law, which is going to end in the menu labeling area, is better than the national law. It is a trade-off. I hate preemption. I have one Supreme Court case argument to my credit, and I lost, but it was on preemption, and I had Bill Rehnquist, so I felt at least pretty good about that. It's a terrible doctrine. When I was with the AG's offices, I became what I called a Dixiecrat because I was in there arguing states' rights, which had in the past been used for some really horrible behavior. But the whole idea is to trump state law that gives more protections to its citizens. The laboratories of democracy, of which Justice Brandeis spoke, were shut down by preemption. Occasionally, I think it's probably a principled thing to do when it would be conflicting and confusing. But in this area, it is always used to, in an usually unsuccessful effort, to preclude lawsuits based on UDAP laws that would protect people. We see it all the time. They usually lose. But it's not unheard of for them to win. We don't bring lawsuits that we know are subject to some of the preemptive language in the Food, Drug, and Cosmetic Act, which is where the preemption came in.
Thank you. Another question.
I have a question related to the extent to which a subject of advertising can apply to right now in public health, where there's some excitement around using kind of some advertising tactics to sell healthier products. So like there's a big baby carrots campaign, kind of marketing baby carrots into an extreme, to try to sell baby carrots. And on one hand, children can't distinguish the subtleties of advertising, but adults can see this as being kind of ironic and witty marketing. But to the extent that if these kinds of tactics catch on, to what extent is establishing precedent with deceptive marketing arguments for bad foods potentially then influence good food markets of similar tactics?
You know, there's a great organization here, the Campaign for Commercial-Free Childhood, run by Susan Lin and Josh Golan. And I have always accepted personally their argument that you just can't market to kids. There are those in the advocacy arena who are perfectly fine with deceiving children into doing the right thing. That would include every parent on God's green earth. I talked to a child psychiatrist at Harvard named Alvin Poussin, who's just, I've only talked to him the once, so I can't, we're not tight buddies, but he's very, very good. He was an advisor to the Cosby Show, so how cool is that? And I said, people in my organization are thinking that it may be okay to market carrots, SpongeBob carrots, to kids. Why? And I understand the social science that the kids are deceived, but why should we care? Why is it wrong? And I love this metaphor. The scientists I talked to didn't necessarily agree with it, but Dr. Poussin said, you don't want a kid to eat 6 apples. And that was just a golden way of summarizing that the kid's not going to get the right marketing message then either. That's why it could be problematic. I don't know what happens if you eat too many carrots, because I don't know that anyone ever has, unless it comes with ranch. But it's a very hard question, and I just come down personally. And here, I need to say that I am not necessarily expressing the views of CSPI and not necessarily my own views. But I come down personally that I just say you don't market to kids. Unfortunately, the only comparison we have in this continent is Quebec forbids all marketing to kids. And whenever I have to agree with the Quebecois, I get nervous.
I think one
French
of the
fries. May I say more?
One of the concerns that I have about this, particularly when we talk about the SpongeBob carrots, is that this is being used as sort of a I don't know what you call it, whitewashing, greenwashing. There's some washing that's going on here. That's like, look, you know, SpongeBob maybe also be selling the macaroni and cheese and this snack and that's mostly corn syrup, and this other snack that's has no nutritional value, and those are being advertised heavily. But look, we also do carrots. So Viacom, you know, can point to those carrots, and you know, this is something akin to sort of the corporate social responsibility initiatives that also allow these corporations that are marketing very unhealthy foods to kids to be able to point to some activity they do and say, but look, we do all this other great stuff.
It's
Ronald
like
McDonald
massive
House, yeah.
coal people
Or Pepsi Refresh.
Woodsy
Sorry.
Owl.
Right.
It is. It's either a sop to their own guilt or an attempt to dissuade from what's going on behind the curtain, which is all of the other abusive practices. You're absolutely right. But another one of those tough questions as to how do we get kids to eat well, and I think the main thing is we give the, you know, keep coming back, give the parents better choices. Don't give the parents only limited choices.
But I think that comes back to the question we had beforehand as well, and maybe it'll be discussion later on today. It's not only giving them a choice, this is bad, I'm not going to do it, but you've got to give them the positive choice as well. It's not, you know, that's not healthy for you, don't eat it, then what are you going to eat? And giving the alternative. And I think as advocates, what's important for us is also to focus on providing the positive option while trying to defeat the negative one. And I think that's important. You know, one of the other things, as a litigator, again, and I'm showing my stripes on it, I was talking to someone about what I did and said, God, it must be wonderful, you know, 35 years of practice and you're fighting for justice. It must feel really good. And I said to him, it felt really good until the defendants beat the crap out of me. And I just, you know, want to remind people that we are talking about taking on a multi-billion-dollar industry that has a great deal at stake in continuing things just the way they are because of the profits that are inherent in it. And as wonderful as the three of us in our respective organizations may be and others in this room may be, we can't match, you know, resource to resource in any universe that I can think of in terms of it. And so that using litigation as a tool to take on, you know, tugging on Superman's cape, you've got to be aware of what that's going to mean and what's going to happen. Doesn't mean that you're not going to win. It's just, it's a slow process. It is one that will be filled with defeats before you get to victories, and you have to really know what you want to achieve and how you're going to get there before you get started. It's not going to change overnight.
It's a long, hard road to hoe, but it is very much worth it. I have seen just in the 6 years, I have seen changes that we helped accomplish, and I'll tell you, it's having been just a tiny part of getting trans fat out of fast food menus. There are many ways you can be a great plaintiff's lawyer, but doing this kind of stuff,
I'm just
it's
speaking
wonderful.
In terms of the students, particularly here.
Oh, it's hard as hell. You're going to lose.
Just don't, you're going to.
However, you will lose. But look at our website. We've lost 2 versus winning 15 or 20 and influencing other behavior. And the 2 we lost, we didn't make crappy law. We lost on procedural grounds. It's hard, but the other preach I would make is it's no harder to sue McDonald's than it is to sue anybody else. It's actually sometimes it's easier because you get a better class of defense lawyers. And I don't know if anyone here is a defense lawyer. I'm sorry, not for what I'm about to say, but for the fact that you're a defense lawyer. But I've had more random act of legal nuttiness coming out of people who are not experienced lawyers. The big firms, well, it's still nutty. But they say it with a whole lot of eager young associates doing their bidding. It's a hard road to hoe, but it's a real good one. Any type of advocacy, if it's worth doing advocacy work on, it's always going to be uphill, because if it was easy, it would already be done.
I think the other part of it, Steve, is that, since you've already pointed out our age on this, it's something that changes over time. And you can see, I've been at NCLC 12 years, you've been doing your work 8 years. It takes time, and there you go. But, it's something that is incremental, and that one of the things you need to be able to do on this is to have a goal where you want to get to and a plan on how to get there, and understand that there are going to be bumps in the road as you go along. Anytime you try to do this kind of social change on it.
I think we also need to get more people involved.
Absolutely.
I mean, it's almost
we're getting old.
I think CSPI has been a leader on particularly on these consumer protection actions, and I don't know how much company you want, because you're worried that people could get involved and end up making crappy law. But
particular people, I got to say, their intentions are good. The people I worry more about, the greed heads who just want a quick settlement for dollars, they make the really bad law. They're getting the bad judgments.
But we just need more folks out there doing this, so don't be dissuaded by the possibility of having your butt kicked.
Here's a plug. We do have summer interns. Our main office is in D.C., but if you're really lucky, you can come work with me in Dallas, which is just it's just wonderful.
Dallas in the summer. Dallas in the summer. My mind just...
Well, as our slogan is, not as humid as Austin. That's all we got going, and it was just a 3-hour drive.
We have just a few more seconds here. Is anyone else who have any questions or comments they'd like to be able to make? You've actually been great. We were hoping that you would be asking questions, and not only you ask questions, but they were good questions, and we really do appreciate that as well. Anything else? Well, if not, I'm going to stop and thank Mark and Steve for taking the time this morning and leading us to a great conversation. Thank you as well. Any announcements?
Can I ask also to clap for Stuart, who I think is a wonderful. And we'll be here all week. Tip your servers.
Thank you, guys. I think we're all very lucky to have 3 such authorities here, and I really appreciate the discussion. So thanks a lot. And now is lunchtime in about 4 minutes or so. So you guys can head down to the Commons whenever you want, and we'll have an hour to eat.
Fast food.
Yes, exactly. Burger King and Wendy's and...
Will there be a toy?